Now for reaction to this ruling and insight into the broader battle still playing out over the health care law, we turn to Neera Tandon, former senior advisor to Health and Human Services Secretary Kathleen Sebelius. She's now the chief operating officer for the Center for American Progress, a liberal advocacy group, and David Rivkin, lead counsel in another health care challenge, this one filed in Florida. As Betty Ann just reported, attorneys general from 20 states have signed on to that lawsuit. David Rivkin, how substantially does the judge's decision today weaken the underlying health care law?
It's a major blow. It's a well-reasoned decision that went to a great degree in analyzing what lies at the heart, the problem at the heart of your statute. You can regulate commerce. Congress can regulate commerce. Congress cannot compel commerce. There's no precedent for it. If you go down in the direction, you produce the federal government exercising general police power that's reserved to the states. The goals, as General Cuccinelli said, are noble that underlie the statute. The government done it in the wrong way. They've done it in a fundamentally unconstitutional way.
Neera Tandon, your response to the same question, how much does it weaken the law?
Well, I think it weakens a fundamental protection of the law, which is pre-existing conditions regulations, but it doesn't actually overturn the overall law, which is what the Virginia Attorney General requested. It strikes at a particular provision, the individual mandate, but there's a lot of other provisions that provide protections. So it strikes at an important part. It's not an unimportant part, but it does not undermine the whole law. But we believe this will be overturned, and we agree with the White House that this will ultimately be resolved as constitutional.
As Betty Ann reported, Ms. Tandon, we have seen two other challenges so far, and they have upheld the law. This one, at least this key critical provision, was not upheld. What's the difference?
Well, the judge found differently. He took the same set of facts and disagreed with the finding that it's constitutional. Obviously, he found that this kind of activity where people are choosing not to have health insurance in a system where we live in a system where everyone gets health care at one point or another, and it's just a decision when to get health care. They get coverage. They're in everyone who goes to the hospital is covered in our system, and so it's a question of purchasing health insurance. Other judges saw this same set of facts and said it was not unconstitutional. He looked at the same set of facts and found them constitutional. We're seeing a partisan split amongst judges on this decision.
Is this a partisan split? And whether it is or not, how does this affect what you do with the upcoming case in Florida?
It provides some good reinforcement for our case, and we're very optimistic about that case. But let's get something off the table. Very unfortunate to talk about in partisan sense. Frankly, when I go before a judge or judges, I don't even check which president appointed them because they're not functioning that mode anymore.